I'm Nikos Ilia, and I'm the chairman of the Cyprus branch of the Chartered Institute of Arbitrators. And it is with great pleasure that I welcome you all to the first webinar organized by the Cyprus branch. I'm happy to say that it's well attended, and we have attendees from all over the world, not only Cyprus. As most of you may know, the Chartered Institute of Arbitrators is the world's leading qualification and professional body for dispute avoidance and dispute management through a global network of 16,000 members who are all trained or being trained in dispute resolution and are bound by the Institute's Code of Ethics. If you're not already a member, I encourage you to contact CIARP to find out how you may be trained and become a member. Well, we're all here today, not only because of COVID-19, although that played a major role, but also because of our common passion and interest in dispute resolution, and in particular in ADR. The COVID-19 pandemic impacted not only the way we live and do business, but also how disputes and differences are resolved on a local and at international level. And in our efforts as a Cyprus branch to contribute positively to the global ADR community, we have chosen to organize this webinar, this first webinar for the Cyprus branch. But more about today's topic and our accredited speaker from Nadia Elbaroudi Kostrikis, who is a fellow of the Chartered Institute of Arbitrators and member of our committee, and is the moderator of today's webinar. To you, Nadia.
Thank you, Nikos, for the introduction, and please allow me to also welcome everyone. We're very fortunate today to have Professor Mohamed Abdel Wahab as our guest speaker. We thank you very much, Professor, for accepting this invitation and for finding some time for us out of your very busy schedule. Professor Abdel Wahab, thank you. Professor Abdel Wahab needs no introduction in the arbitration community. But for those of you who did not yet get the opportunity to come across any of his publications, attend the countless conference and webinar in which he appears as a speaker, meet him in person or e-meet him, I will provide you with some of his credentials before addressing the topic of today's webinar. Professor Abdel Wahab is the founding partner and head of international arbitration instruction and energy groups at Zulfikar & Partners law firm in Cairo. He is the chair of private international law and professor of international arbitration at Cairo University. He is one of the vice president of the ICC International Court of Arbitration. He is a member of the board of trustees of the Chartered Institute of Arbitrators, member of the governing board of the ICCA, and member of the governing board of ICODR, International Council for Online Dispute Resolution. I will stop here, but you can find a complete list of all his affiliation, position, and many other information about him in his bio on the CRB webpage, and of course on the Zulfikar & Partner website, along with his CV. Professor Abdel Wahab has an extensive experience and broad knowledge in the field of international arbitration. He served as an arbitrator, counsel, and legal expert in more than 200 cases involving African, Asian, European, Middle Eastern, and US parties. He is the recipient of numerous international awards, including the ASA, Swiss Arbitration Association, Global Advocacy Prize, the IA Hall of Fame Award for the African Arbitrator of the year 2019, and the 2020 Prime Choice Award. Most recently, he was nominated for the Global Arbitration Review COVID-19 Pandemic Response Award. Professor Abdel Wahab is a visionary. He has been advocating relentlessly for the use of technology and alternative dispute resolution mechanisms as far back as 2001, and he's still doing so. His excellent publication and passionate advocacy in the field have greatly contributed to the rise of online arbitration. He is the author of several articles dedicated to the use of technology in international arbitration, and is a co-editor with Professor Ethan Koch and Mr. Daniel Raymond of a leading treatise in the field titled Online Dispute Resolution Theory and Practice, published in 2012. This treatise received the CPR Award for Best Dispute Resolution Work in 2013, and a new edition is due to be published in early 2021. With the outbreak of COVID-19, the acceleration of the use of technology in international arbitration, and the increased number of requests for virtual hearings, his valuable knowledge represents a great asset for the arbitration community, especially that he participated in several fully virtual hearings since March 2020. I think around 7, if I'm not mistaken, Mohamed. Indeed, despite the wide technical and logistical support from arbitral institutions, there's still many diverse legal issues that ought to be considered when assessing whether to proceed with a virtual hearing or not. In this context, Professor Mohamed Abdel Wahab will present the Abdel Wahab Pandemic Pathway that is intended to assist parties, counsels, and tribunals when faced with a dispute over whether an online hearing should be held, on the merit should be held or not. Without further ado, please join me in welcoming Professor Mohamed Abdel Wahab.
Thank you very much, Nadia and Nikos. Can you hear me well?
Yes.
Thank you very much for the generous introduction. I'm delighted to be part of this first virtual webinar in Cyprus, in as much as I would have had the pleasure of being there physically in person, in a place that I like very much, Cyprus. Unfortunately, COVID does not afford us this opportunity, but I'm happy to join remotely though. Let me start by saying that I'm very grateful for our participants, and to add to what Nadia has mentioned about the forthcoming edition of our 2021 ODR book, I also have the pleasure of co-authoring a chapter with Mires Philippe, who is a world-leading authority on ODR, and she's joining us today as well, when she was greeting everyone. So delighted to have you, Mires, and everyone as well who is joining us. Now, many of you would say, what can possibly be said since March, where we have had webinars weekly, monthly, daily on issues of virtual hearings and COVID-19, what can possibly be new? There is an element of truth into that, and that was troubling me since yesterday when I prepared my presentation. But what I promise you is that it's different from what I said before in both of approach, content, and even approaching the pandemic pathway that I had proposed since May. I hope you would enjoy the presentation. I'm looking very much forward to the subsequent Q&A. But I will say the following. I will start off on possibly a funny, interesting note. Then I will move gradually into more of the substantive, heavyweight lifting of legal and practical issues so that we can have a smooth transition. I will start by sharing my screen with you for the presentation, and I assume you can all see it now. Now, basically, the topic, as I mentioned, online arbitration hearings, legal considerations and practical implications, a pandemic pathway. Now, how I intend to structure this is to start with an overview of what I will cover, the status quo of COVID-19, between the usual thing, hope and fear. I mean, we're addressing, of course, legal issues, but we can't separate our lives from our professions or what we're doing in a way. So there is hope and fear cutting across our personal encounter with COVID-19 and professional encounters as well with what we do professionally. And then I will give a brief synopsis on online arbitration hearings and online dispute resolution. Is there a distinction to draw? Because everyone now talks about online dispute resolution when it comes to virtual hearings, and that is presented as if it is online dispute resolution or online arbitration stricto sensu in a way. So we have to address that. Then I will move to the legal considerations and the practical implications through the pandemic pathway before I make some concluding remarks, which I hope you will find interesting to see with me what I expect will be upcoming. Now, to start with, I think since we are referring to COVID, it deserves a good, let's say, introduction. And so this is the latest since yesterday. I think we're all familiar with these websites, the Johns Hopkins University live update. So we have about 35.6 or 7 million so far. We've got about more than 1 million deaths, and the numbers are rising. But if you look at the bottom, apart from the cases by states, you look at the bottom part in the right-hand side, you'll see an orange graph like this. This is the graph since March of the COVID cases. So it's rising globally. It's not flattening, it's not declining, it is rising. So I think that's the takeaway with this. Now, we all know that, even though we can't see it physically with our own eyes, we know how it looks. And there it is. And this is what it has generated, is that everyone is concerned. We don't easily have visibility on how easily it can be contracted, transmitted, and I'm not giving, of course, any medical presentation on that. The reaction of every person is different from the other. It has transformed our lives personally, whether it's an interim transformation or more of a long-term one. One thing is for sure, it has changed approach and perceptions to many things, and this is destined to continue with us for some time. Then comes the point is what have happened? How are our lives affected before and after? When you look at European, Asian, US cities everywhere. Now this is part from Germany before and after, Italy, Rome, before and after COVID. You look at sometimes empty cities, and we've all seen videos of this. Even Disneyland at one point in time, which was always glamorous with its writers, was empty in a way. So reality, this is what has happened, and which has casted shadows on even how we conducted our own business and continued to work despite the odds. Now, again, everyone, I think, we want a normal life. Now, everyone is talking about the new normal. What is it? How can we go back to the lives we've had and which we may have taken for granted for a very long period of time? The basic gestures of shaking hands, hugging, embracing people, expressing emotional content is now under scrutiny and is now met with skepticism, concerns, and fears. That is not normally part of our social interaction as humans. So people still crave for a normal life, and that even happens in hearings where you don't easily have physical hearings like before, and when that happens, there is physical distancing between members of the same team, let alone those across the table. And the tables have gotten bigger, wider to allow for further distance. So there we go, normal life. So this begs the question, how can we achieve a normal life? Well, we can resort to a number of options. Going back to a normal life, and I'm coming to an end towards my funny and interesting start from my perspective. We can resort to Greek mythology, for example. Can Medusa help? Well, Medusa cracked the Kraken in Greek mythology. She looks at anything and can turn it to stone. But can she help with the coronavirus that we can't see? Well, she can't look at it because she can't see it herself. And the virus does not necessarily have eyes. So how can you turn it into stone? So this means if Medusa was alive, she would also be masked because she would not want to catch the COVID-19. So what we're all waiting for, I think we all know the answer. And I just clicked to show you, but it takes time because we have been waiting and we'll wait longer. We're waiting for this. We're waiting for the vaccine in hope that we can go back to our lives as we originally envisaged it and managed it for as long as we lived. Now, even when we go back, there will always be shadows of doubt, reality that things have changed and will change. And this is already happening. It's not simply an empty promise that I'm making you or a vision into the future. It has changed. And this is what I intend to cover with you now. So what happened with all that, when we take this into the arbitration world and the legal world, the COVID-19 actually, people talk about revolution, and it is a revolution from the perspective of many. Others think of it as a catalyst. And in relation to technology specifically, it has catalyzed things. So expedited resort to online platforms, means of resolving disputes using online technologies, because at one point in time, at least in the first weeks and months of the pandemic, that was the option. So it brought us to the point where we had to put to test as humans our resilience and survival instinct in order to be adaptable and intelligent enough to adapt to the new interim normal, to say the least, in Darwinian type of approach. Now, the arbitration, and I've been calling this the Snowpiercer since April, has not stopped. Even when winter has come through the coronavirus, still the arbitration train has not stopped. Courts across the globe have, at least for some time, either ceased their hearings or their work until they were able to digitize their platforms and able to conduct their cases online. In some jurisdictions, not even all. But arbitration was very adaptable and very quick and swift in adapting to this. So it continued, and arbitral institutions, parties, and practitioners have released so many protocols, initiatives, projects, even shared views about how things are done online, in the online world with the available technology, and quite successfully doing so. Now, of course, not every case proceeded online because there are certain specificities regarding certain cases that postponements took place. But let us move from the abstract to facts and figures. So here is part of a closed arbitration blog by Sophie Nappert and Mihaela Apostel about healthy virtual hearings. But they say courts and tribunals in England and Wales reported an increase in audio hearing by 500%, video hearings by 340% between the last week of March and the first week of April. So that's in 2 weeks' time frame. And then arbitral institutions and hearing centers have experienced an exponential hype in the use of virtual hearings. Now, as we say, sometimes the calamities of many come in as benefits to others. And of course, those engaged in IT and ICTs and the use of technology have, of course, benefited a lot because products, services are on sale and accessible by many. Even the overall internet usage worldwide have quadrupled, if not more, globally because of the lockdown or the restrictions that spanned the globe. Even in Seoul, in the International Dispute Resolution Center, they've reported a rise of 500% in virtual hearings, more than 460% of days held virtually, and 85% in the Hong Kong International Arbitration Center cases have increased. The ICC experienced similar, the LCIA, all arbitral institutions worldwide. In fact, ICSID, for one example, started by having their own dedicated platform for investment arbitrations involving states, and hearings are smoothly being conducted virtually. Again, a confirmation to the arbitration Snowpiercer, which has managed to continue despite the odds of the COVID-19 crisis. Further than that, DELOS has put together a great resource list of available. It's more than 90 plus resources on virtual hearings. I've put in the website for you. And between April and September, there have been a surge, as I mentioned, call it virtual, remote, online initiatives, ICC protocol, LCIA, Hong Kong VIAC, Milan Chamber, the ICSID, Stockholm, name it. I mean, all institutions have put in place initiatives and protocols to deal with this or mitigate the effect of the COVID-19 pandemic on our pending arbitrations. So you can definitely, at your leisure, look at the 90 plus resources which are accessible on the DELOS website. Then the latest newcomer, and it's not just something that I'm proud to see coming to fruition, International Arbitration, the COVID-19 Revolution, which is a book that I was invited to co-edit with my esteemed colleagues, Professor Maxi Shera and my esteemed colleague again, Ms. Nusa Bashiri, where we have amassed and had a lineup of world-leading authorities that contributed to this seminal work. But one interesting chapter that fits in the framework we're discussing today is basically about a survey that has been conducted by Gary Bourne, Annalise Day, and Hafiz Verji of Delos, an empirical study of experiences with remote hearings, a survey of users' views. And I think I'll spend few slides to address you on that before we move forward, because that sets the stage on where we're coming next. So here we go. There's been a prevalence of fully remote hearings in the second quarter of 2020, and that was 10 times greater than any time previously. The collective experience of users based on that survey, and of course we have to understand the limitations of the numbers that are being surveyed, of course, but have still expressed a preference for a physical in-person or a semi-remote hearing over a fully fledged hearing. Now, let's not forget there is a psychological dimension to that, as well as cultural and technological, is that people are pushed out of their comfort zone. We're accustomed to physical face-to-face hearings. It comes with its own pressures, own requirements, own demands, and now to take that to a wholly new level of remote hearings that either in part or in whole is quite interesting. So people are still adapting to this. And in this type of adaptation, still expressions of an initial preference to what was a comfort zone is psychologically acceptable and let's say not surprising in a way. And fully remote hearings have been integrated into the toolbox of practitioners. So it's not anymore something that people do not think of. It's something that is on the table as an option. And service providers have tailored their platforms and services to cater for these needs. And again, moving forward, those with experience of remote hearings reported, so those who have actually experienced it, having myself sat in a number of remote hearings since March at least, there is greater willingness to propose it in the future. It does not always go 100% flawlessly, but certainly it has worked beyond average satisfaction, and in some instances have been praised by many and those who have had skepticism initially. Surprisingly or not, sometimes the technology used and the platforms used have delivered excellent results for hearings for both or more parties if it was a multi-party. So again, this is all available in the book and in the chapter put forward by Gary, Annalise, and Hafiz. And then they also addressed hearing dates in flux. So they measured a number of things, considering since the commencement of the pandemic, and I call it the Pandemic Hearing Index. So the cases that were already commenced before the pandemic, and in the initial disruption of the first few weeks, you had scheduled hearings and hearings that were coming in March, April, May, June, up until today. How did parties deal with that and counsel? So at the time of the survey, 38% of the hearings were not postponed. And that's remarkable. People have not postponed their hearings, and that's well above the threshold of 1/3 of the cases. Arbitral institutions have even experienced an increase in the number of the cases since the pandemic. And the hearings that were postponed, new dates were set, and this were 41%. And here there is a twist, because setting new dates means that, yes, there could have been an initial disruption, but you have set new dates and you are going virtual or optionally physical, but irrespective, setting new dates despite of the lack of visibility of what's going to happen is a further testament to the fact that people were moving forward despite the odds. And despite the lack, you remember the slide I was saying we want back our normal life, people have adapted to this. So broadly speaking, we have 79% of cases were moving forward, either by maintaining the hearing dates or by setting new dates during pandemic times. And there are, of course, for legitimate and logical reasons, a postponement with no new date set, because either parties do not have visibility or still want to have physical hearing, and this was 15%. So that again is a remarkable number. And then there were cases which settled independent from COVID reasons, 4%, and those that settled because of COVID, and that was 2%. Again, based on this empirical survey of the people who were surveyed. And then another interesting twist in the chapter and the study put forward and included in the International Arbitration and COVID-19 Revolution book is that 74% of the participants in the survey reported they have participated in fully remote hearings. And that is again a remarkable number at the time of filling out the survey. So you can imagine that by June, because that was the time when it was conducted, that was the case. So from June to October, you can imagine that the numbers have significantly risen. Now, of the participants, the 74% that reported they have already participated, 78% had no more than a week, 5 sitting days. So 78 of the 74% have had experiences of no more than 5 sitting days cumulative experience, and 49% only had 1 to 2 days experience. And some clear preferences have emerged as a result of the survey. For example, respondents, and here we are talking about respondents not in an arbitration, but those responding to the survey, were asked to compare less good, same, or better, different types of hearings in relation to defining features of the hearings. So the criteria was that 6 criteria related to the examination of experts and witnesses, 1 in relation to advocacy, and 1 in relation to understanding the case, and 2 in relation to understanding the case from the tribunal's perspective. So you are comparing fully remote hearings to semi-remote hearings and physical face-to-face hearings, which people are accustomed to. The majority of responses placed fully remote hearings on par with physical or semi-remote hearings as well, at least in certain respects. Now, of course, some of the respondents to the survey considered that fully remote hearings are less effective than physical in-person hearings and semi-remote hearings. And we will touch on this when we come. And the specific area that has been highlighted by people was in relation to witness and expert cross-examination. Now, of course, that you would understand, when a witness or an expert takes the stand to testify and gets cross-examined, they are in one hearing room with the tribunal and the party, and the counsel who's cross-examining them has them in the same place. It's not necessarily their comfort zone where they are staying at home or relaxing, and there is a degree of pressure. For good or for worse, this has, been tested for decades through physical face-to-face arbitration hearings. But when it comes to remote arbitration or virtual arbitrations, the witness or the expert could be sitting in the comfort of their own homes, offices, alone in the room. They are not under or within the grab, not within the physical grab of the cross-examiner. So again, psychology plays a role in terms of when you are surrounded by an environment with which you're familiar, there is less pressure on you. And this means your performance could be different. It could be better to you, not necessarily for the cross-examiner, or vice versa. And how the tribunal would perceive that, in fact, of body language, cues, how this is being read. Sometimes even the fear by cross-examiners or the tribunal that if a witness or an expert does not feel that they can immediately answer the question, there is a possibility to come up with a technological problem, and it would be difficult to ascertain whether this is true or not, whether the person has his mobile phone switched off or having notes. And tribunals in real hearings and the cross-examiner have to check the surroundings of the witness or the expert that they have no access to anything but what they are expected to have access to, which is their reports or statements. So all these elements come into play, let alone the technology and the use of the cameras and the bandwidth and the internet, which we will discuss in due course. And again, one of the quotes from this chapter 7 of the book by the excellent empirical study done by Gary, Annalise, and Hafiz is that remote hearing seems to push tribunals to be more effective in managing the hearings, push the parties to be more respectful of the organization of the hearing. So in a nutshell, in a virtual environment, it is true, and I have seen that parties make better use of their time. Because you don't know whether technology will fail you at a certain point, so you want to cut the chase and get along with the best part of your cases, which makes better use of your time and more efficiency. And then the responders to the survey have said, it has been our experience that the parties tend to wait and listen more, tribunals have a better chance of asking questions, witnesses and experts are seemingly less on the spot and being more relaxed and sometimes clearer in their testimony. Again, the environment plays a role. Trends. Now, of course, there's much more when you read the book and the chapter, but to distill few trends is that participants with prior experience of fully remote or virtual hearings have more physical in-person hearings scheduled in 2021, COVID-19 permitting, of course, than fully remote hearings. People want to go back to their perception and originally perceived normal life. And part of that normal life is the normative physical hearings. So there is an anticipation, high hopes that 2021 will enable them to proceed with their physical in-person hearings. I, for one, have a hearing scheduled in January 2021, and there is no visibility whether it can proceed in person or not. And the parties have been offered the opportunity to proceed virtually. And most likely, if things don't work out well, this could move into a virtual hearing as well. Participants, again, another trend, have clear preference for in-person or semi-remote hearings over fully remote hearings, again, with the psychological twist. Not because that full virtual hearings do not work, but still people are finding the physical face-to-face type of interaction brings an element into the process, not necessarily tangible or visible, but when you talk to people, they say something is missing. Well, something is missing psychologically or because of technology. One thing I can tell you, a tribunal, when they retreat into the room, the ability to discuss over lunch is now different because everything is virtual. Counsel who are not in one place will prosecute the case differently from what they would normally do physically. Instead of normal physical breakout rooms, now we have virtual breakout rooms on the platforms we're using. There is also another trend, smaller value cases or cases with no or fewer witnesses and experts to examine are more likely to be conducted as fully or semi-virtual or remote hearings. So if you don't have witnesses or limited number of witnesses, small value, depending, it could be more cost efficient and more productive for people to move virtually because it's also easier to find a hearing date that meets everyone's expectation if they don't need to physically travel abroad. So that is, and again, an element to take into consideration. And I think one of the highlights of that survey, which I initially, in one of the early webinars in April, I mentioned as a possible concern that I think will happen, and the survey actually confirmed it, is that arbitrators now find greater willingness to propose fully remote hearings for the future. It is indeed easier for arbitrators to sit virtually compared to counsel prosecuting the case virtually. And so it's easier. The concern, of course, is whether arbitrators are going to pick and choose whether to go physical or virtual, depending on the destination or the seat of arbitration. Whether you want to make the trip to a remote location or destination on the basis of subjective views, or whether you prefer to go virtual because that's more effective. That remains to be answered and is an open question, of course. Now, moving to the second part, which is, we've been talking about virtual, remote hearings, studies, surveys, writing, scholarly views, practical experiences, protocols, initiatives. And then over time, people looked at this smaller picture, one aspect of the toolbox, which is hearings online, and then started magnifying this and presenting it as if this is ODR strictus sensu, so pure online dispute resolution. So it has finally arrived. Well, online dispute resolution has been there since the 1990s, 1996, 1999, when Ethan Katch wrote his book on online dispute resolution. And then a group of experts got together to develop online dispute resolution. And at the time, even up until the COVID-19, people did not feel strongly about this as being online arbitration fully fledged, and were more content to proceed traditionally with a dint or some tools of technology alongside the arbitration process. Like you can use video conferencing in a procedural hearing, interim measures hearing. You, of course, exchange emails. You use an online platform. This has always been the case. But at the time, no one called this online arbitration strictly and purely. It was simply an element of technology integrated into traditional arbitration. But since COVID-19 kicked in, what we originally perceived as a tool became a characterizing element of a traditional process and transformed this, oh, this is online arbitration. Well, online arbitration or online dispute resolution is a field that goes well beyond the boundaries of online hearings. Now, whether they are the same or different to many, experts even disagree, even within the group of experts on online dispute resolution, and I'm sure Mirez would be smiling in the background. We could not agree whether simply a traditional arbitration with an online hearing component is online arbitration. I, for one, do not think that it is purely online arbitration, because there must be something additional to that. You're wholly conducting it online. There is no physical seat, no physical venue. It's paperless. All this. We have not reached that stage yet. There are online arbitration rules by Russian institutions, Chinese parties, US parties, or institutions, I mean, and that exists. But still, traditionally, arbitration has made better use of technology, but we are making the transition to an online arbitration completely, but this, we're not there yet. So to call this ODR or online arbitration in an abstract, pure manner, I think is beyond what we are seeing today. But others may disagree, of course. And part of it is promoting ODR. Well, if that is ODR, then it's gaining momentum and field, and all practitioners who are now ODR experts can claim that virtual hearings have brought us not only closer, brought us into the age of the world embracing online dispute resolution. But I gave you my view, I gave you others' views, and you're free to consider your views. Of course, if you're interested, there are writings on online dispute resolution and online arbitration, and you can definitely consult this and shape your perceptions accordingly. Moving to the remaining part of our submission, which is the legal considerations and practical complications or implications with virtual hearings or online arbitration hearings, to use a neutral term. I know some people favor virtual, others favor remote. So I thought of calling it online because that's the common feature of both. The parties' rights and obligations. So we have overriding principles that have existed and at least will continue to exist for the foreseeable future. Party autonomy reigns. So this is an important legal consideration when we are assessing the need to move with a virtual hearing or not. So if both parties agree, then everything is green and great, and no one is having a problem. But the reality is parties disagree more than they agree, and we have to decide that. Another element is unilateral right to a hearing. If a party calls a hearing, should the tribunal answer without any discretion? That is a pending question. In many arbitration rules and laws, if a hearing is requested, even though it's not mandatory and it's not public policy that you should have a hearing, if one party requests it at least on the merits, they should be answered. And I think that's sensible and that's fair. The questions that kick in, of course, is at what cost, what expense, who's paying for it, the time available without delaying the process and making it efficient and expeditious. One thing that I think is a new development that is also very good, there is a new ECHA task force constituted by 3 leading practitioners regarding assessing the question of is there a right to a hearing per se? So they're going to assess that from different jurisdictions and different rules and laws to see whether our perception that when a hearing is requested should be immediately answered and granted is going to be put to test based on strict legal considerations prevailing in a number of jurisdictions. And that, I think, is a very important project for ECHA and the task force constituted to handle this. And there is always the all-time favorite, due process, which is always a double-edged sword. You can use it and you can abuse it. And you can see it from different perspectives depending on which side of the pond you are. Is going virtually against one party's will a breach of due process? Is that something that you can answer in the abstract? I think it's fact dependent. And it depends on the case, and we will assess those factors. But there is a paranoia indeed, and we need to strike a degree of sanity and bring an equilibrium to this. So, for example, traditionally arbitrators, out of abundance of caution, when a party requested a hearing and insisted on it, they would proceed with it out of abundance of caution, because they don't know whether in the specific jurisdiction or another jurisdiction of the 165 member states of the New York Convention, one judge sitting somewhere in a remote location would say, you have breached the due process right to have a hearing. So that was the case. Now, this has become more complicated and multi-layered because it's not about a hearing per se anymore. It's about whether a physical or a virtual or an online hearing is a requirement. And that, I think, is an element that plays into these legal considerations. And this brings me to the 4-step analysis that I did propose in April and was published in May by GAR. In this regard, the Pandemic Pathway. Alison Ross kindly published this as well with our esteemed colleagues from GAR. And here we go. So the 4 steps. The first one, my suggestion, again, we're looking strictly at the legal considerations. If the applicable law governing the proceedings, the lex loci arbitri, expressly refers to in-person hearings on the merits. And not just that, because many rules refer to in-person. Now, the perception was that they thought in-person, one could argue, is that we made physically, because no one contemplated that you're going to have strictly virtual or fully remote hearings or online hearings. That is one way. But I think one factor when you interpret that, and we all are very well educated about interpreting legal text, is whether in-person unequivocally means physical appearance. Now, for example, today, all of us participating in this webinar, we are who we are. I am the same person when you see me physically as the same person sitting across the screen. I am not a different person. That's not a holographic visual projection of me. I'm just appearing virtually in an online manner, but I am the same person. I'm just not in flesh and blood in front of you. So that is the point. So you need to factor this when you construe the word in person, because in some rules and laws, in person is contradicted and is contrasted with being represented through a third party. So you appear in person because you appear yourself, or by proxy through someone else. So that is, I think, the first step, to look into this. Of course, if the agreement of the parties is not there. Now, we agree, if the parties are in agreement, so be it, their agreement stands. But we're discussing, if there is no agreement, how should tribunals and counsel proceed? And the second step, if the lex arbitri or the governing procedural rules expressly refer to online hearings or possible use of ICTs, then in that case, life would also be easier, because then this means consent is not required, because you have already consented to the application of the rules or laws that have already included an ICT component of online hearings. Now, some people may wonder, where can we find those? Well, two examples come to mind. Is the UAE Federal Arbitration Law number 6 of 2018 already has a reference to use of video conferencing and ICTs in arbitrations. Quite innovative, because it's a 2018 statute. And again, in 2018, the amendments to the Jordanian arbitration law provided for the use of technology. So here you go. And again, arbitration rules of institutions may refer to that. For example, the ICC rules in their annex about effective techniques in managing proceedings expeditiously specifically refers to the use of technology. And the ICC protocol or initiative on mitigating the effects of COVID-19 also refers to the possible interpretation and construction of the words in person to mean that you can proceed virtually as well. And many other institutions have also embraced the same concept, because otherwise the Snowpiercer would stop. Now, of course, it is not set in stone, nor is it the case that I am suggesting that every single case should proceed virtually. Of course not. There are cases for the specific factual procedural matrix that may require a postponement for a physical hearing of sorts, but that remains to be assessed on a case-by-case basis. But conceptually, that would be helpful if you have rules or laws providing for an express integration and embracement of technology as a component. Then comes the third step, which I will address, but I will elaborate more because I have 11 considerations for the third step alone. So the third step addresses if the applicable lex arbitri or the governing procedure rules are silent, so there is nothing for or against virtual hearings, and no direct inference can be made about the words in person, so there is a neutral playing field. How should we construe this silence? Should we construe it as a permission or as a prohibition? Many laws and rules of interpretation provide, well, it is not prohibited unless it is expressed. Others say, well, it's not permitted unless it is authorized. So you need to engage in an interpretation, which will bring me to the 11 considerations that I will address with you shortly. But the fourth step is a situation where you have the lex arbitri, or the law governing the procedures, is inconsistent with the governing procedural rules agreed by the parties, being institutional or ad hoc rules in that sense. What would happen? The law does not allow and the rules expressly allow. Then the way forward, of course, will depend on whether the rule within the lex arbitri is a mandatory or a non-mandatory one. Because if it's not mandatory, then obviously you can opt out of it and your rules would help. If it is mandatory, which would be surprising, at least to me, that you require a physical hearing as a mandatory requirement, because in most laws, a hearing in itself is not mandatory, as we mentioned. So in that sense, this brings me to considering a focus now on the third step and the 11 considerations. So the first one, when we are assessing the third step, we should look at, which is whether the silence is construed as a prohibition or a permission, whether the applicable laws or rules include an express provision giving the tribunal the power to manage and determine the procedural path as they deem appropriate. And I think all institutional rules and laws include that. Absent an agreement of the parties, the tribunal has the power to efficiently manage and decide on the procedural path. So this general umbrella can give guidance in light of the silence that exists in the rules. So that is one factor to consider. Another is whether the rules or the law governing the proceedings refer to the parties' full or reasonable opportunity to present their case, and whether full and reasonable have different connotations in the legal system. In certain legal systems, courts have construed full as meaning something well above and beyond the threshold of reasonable. So that is a factor to consider as well. Another one is whether the parties have access to technology. Obviously, you're not going to order virtual hearings when one party does not have access to technology. Now, of course, there's always the gray area as to what extent technology is reliable, to what extent I'm able to use it. And I think we've all encountered situations where one party said, look, we're not accustomed to technology. We don't know how to use it. We have access to it, but we can't plead our case using that technology. Well, think of it this way. What if you appoint a counsel that is not mastering the language of the arbitration? Are we going to say, well, you've got to change the language of the arbitration to suit that counsel? I think that we need to consider whether there is no access to reliable technology or whether it is preferred and not convenient to a party to use the technology. So access to varying degrees of technology in and of itself, and this is underlined with 1,000 lines, in and of itself is not prohibitive. But if there is an added layer that this presents an obstruction to due process or an ability to one party to present its case, then this needs to be explored carefully by the tribunal in the specific context of the case. The fourth element to consider, of course, is whether the applicable legal principle in the jurisdiction of the lex loci arbitri is whether absent of prohibition a matter is permissible or not, or whether permissibility requires an express provision, as we mentioned. And then we move to the fifth element, which is whether the applicable law or rules consider a hearing a mandatory requirement, and we address that, or whether the tribunal has broad powers. And that again dispenses with the undue paranoia in the field. The sixth one is whether one or more parties object to an online hearing, and I think more importantly, for what reasons. Previously and traditionally, if a party said, I need a physical hearing, I doubt that the tribunal before COVID-19 would impose a virtual hearing. They would go physically with the party. They may deal with it in their costs of arbitration in the award, but again, out of abundance of caution, they would proceed. Now, having tested the remote hearing options or the virtual hearings or the online hearings option, I think now counsel would need to put more effort to justify why a physical hearing is a must rather than as a preference. And this, I think, created now a shift in the burden of proof. Instead of not being required to prove why you need a physical hearing, now practically speaking, and as a matter of what we've seen, you need to reason this request. So that is a transformation in the field. And again, the seventh consideration is whether any terms of reference or practice directions was agreed or included constraints on the arbitral tribunal's powers to proceed virtually. So if you say, for example, and we've seen that in some arbitration clauses, that the arbitral tribunal shall have a hearing in X location in a certain city. Now, this invites an expectation that this is physical presence. But again, we've got to carefully consider the wording. But this is what I mean by having in the terms of reference or practice directions or the arbitration agreement something that guides in this regard. And then moving further, here is whether the proceedings are subject to strict time limits. So if the jurisdiction ratio temporis of the tribunal is about to expire, well, do you have an option not to proceed virtually? It's going to expire. If we don't set a hearing date, and if there are restrictions on travel, what options do you have? So that's again a factor to consider alongside the other factors, assuming you're unable to extend with the consent of the parties, or if there is no institution that has the authority to make the necessary extensions. And I think one important element is, well, assuming the rules are empty, the law says nothing, arbitration law, well, let's look at the laws of evidence and procedure in the pertinent jurisdiction. Do these laws tolerate the use of technology? Because if that is the case, that does inform to a degree the legislative and potentially the judicial approach that courts in that legal system would likely adopt. Because if they embrace technology in one branch of litigation or civil procedure, why arbitration would be denied that privilege, if at all that is possible? So that is something to look into. And then the final two elements is whether the circumstances of the case makes it appropriate. And here we will come to the risk of prejudice, the practical elements that I will discuss shortly before I end with a conclusion. And then finally, the 11th element is soft law instruments that may guide this. And one specific instrument that people do not necessarily are not necessarily aware of is the International Law Association Resolution of 2016 about the tribunal's inherent, implied, and discretionary powers to manage the proceedings. So perhaps when you consider the 11 considerations under step 3, it may at least inform and give you guidance about how to proceed with considering a virtual hearing. Now, the strategic and practical implications. I think informed advice to the parties. So when a party is hit with a request that the hearing must proceed virtually or in an online manner, counsel should inform and advise their party or their client about the likelihood of success if they were object to this, about what level of effort should they put into objecting to this and fighting it, and whether that is a lost battle or not. And then, of course, the compliance with the party's instructions or the client's instructions. But there's always an able counsel will find a way to put the client's instructions in the most appropriate way so as not to lose the sympathy or appreciation of the tribunal at least. But if you go out and say, no, 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 without reasons, what could be done? You need to measure practically the implications and assess them in light of this. So again, counsel now has to play more of a role, a nuanced and fine-tuning into communicating the client's instructions on this matter. Now, of course, the tribunal's approach we've seen moved from a legal requirement mandated by out of abundance of caution approach into a preference or convenience to urgent objections, as I mentioned. And of course, then the technology moved now from being available, accessible, reliable, and also testing the technologies before the virtual hearing starts. This is the dry run tests, which everyone now experiences before a hearing. You're invited to test the platform, know how the technology works, and that's it. Now, of course, when you've done it more than one time and it's the same technology and you're invited to the test, it is a bit of a pressuring thing, but still doing it does help, and it really helps parties, counsel, and tribunals appreciate how things work. And I think the most important element on the practical approach and the strategic approach really is the protocols and orders dealing with online hearings. It is necessary that you have a protocol on online hearings. Now, we've seen that many institutions have offered protocols. The ICC, for one, has this. There is the Seoul protocol as well. There is the Africa Arbitration Academy protocol, which is also excellent, and many, many others. I don't want to cite just a few, but it's just on the top of my mind. But in these protocols, what do we see? We see detailed view on who's going to be the participants, just like entering a physical hearing room, and you need to set that. Login credentials, which platform you're going to use, how are you going to deal with confidentiality, cybersecurity issues? Are you going, I'll tell you, in one recent hearing, every single hearing day, which was stretched over a week of hearings, we've had separate login credentials, renewed passwords, and multi-layered access points. And when you access, there is authentication to make sure that's you. So you can imagine it is not easy. So you need to have protocols that deals with that. And you need to make that user-friendly as well. What software, what hardware requirements? Let me give you a practicality of that. We all know hearing transcripts. When you're sitting in a hearing room, you have a screen in front of you with the transcript. And you're listening to the pleadings or the examination, and you can see the transcript. Well, so far, with the technology available, the live transcript is being taken, but you need to look at it on a different screen from your computer, or divide your screen into two, which may not always be convenient. So some people may have many screens. Now, you have to decide on what works for you without disrupting what you're comfortable to deal with. So again, this is just one fine aspect of the reality and practicality of virtual hearings. The use of cameras, 360 degrees cameras, no virtual backgrounds for witnesses so that you can see their surroundings and the room. A witness looking constantly into the ceiling might be asked to put the camera up so that they see what's happening in the ceiling, all these things. And netiquette. Now, previously, counsel can object by intervening, not ideal all the time, but here, part of the protocol for virtual hearing is that raising hands or sending a message in the chat box or raising a hand, virtual one, depending on how you decide to deal with this within the netiquette provisions of the procedural order. The agenda for virtual hearings, well, from experience, breaks are shorter than before. Hearing durations are normally shorter than physical hearings, but stretched over more days, especially if the parties have different time zones. And then document management systems, which document management you'll be using for the hearing bundles, the e-bundles, annotations, all this. I mean, there are so many good providers out there that have even upped their game and now provided excellent document management systems. Platform service providers, online transcription, as we mentioned, online interpretation. You can now switch channels to hear to interpretation in different languages. So it's simultaneous interpretation rather than sequential one. And in time, I'm telling you, we can even have machine translation and interpretation. But the reality is, you see now the icon of the interpretation appears when the witness who needs interpretation services takes the stand. Recordings of the virtual hearings, technical issues about the internet bandwidth, minimum system operability requirements, update of systems. It required arbitrators, counsel, and parties to invest in technology more, which comes in handy for technology companies, of course. And witness examination, we addressed the comfort versus the discomfort issue, and why now people still think that physical hearings, especially when it comes to cross-examination of witnesses, and specifically fact witnesses, they prefer the way that traditionally has been done. But I think now is the time that people have to revisit the techniques of cross-examination to adapt it to the online world. And of course, cost and efficiency elements. Now, of course, there's the cost of investment into the IT infrastructure, into hiring technology providers, using certain platforms, which are not always inexpensive. But you compare this with the cost of traveling and teams making it abroad and paying for night accommodations at hotels, flight tickets, and you've got to weigh that on a case-by-case basis. Now, moving to the concluding remarks quickly, we know and we agree that there are novel, unprecedented challenges, but this also carries opportunities. On one hand, COVID-19 has pushed people out of their comfort zone, despite to their own disliking, and that's true, to explore the online option. But at the same time, this migration to the virtual world has challenged existing arbitration practices. The way we prosecute cases physically is not entirely befitting of the online environment. And that's why people are now considering and doing their effort to transform the traditional practices, especially when it comes to oral pleadings, cross-examination techniques, and all this. And this has taken the community by surprise. It has revolutionized the way we conduct arbitration proceedings. That is true. Online hearings are now one of the available tools in the toolbox of arbitrators and counsel. You need to balance the requirements of efficiency and maintaining the continuity of the stone piercer vis-a-vis the due process requirement, hence the four-step approach that I proposed amongst many excellent initiatives by other colleagues in the field and other institutions, of course. The issue is, the longer the period we are locked in or using the virtual or online hearings as our only viable option, not possible, viable option, the more receptive people will be, because this then will become your new normal and you'll become accustomed to it. And of course, if that goes on long enough, and I hope that's not because of COVID, but if that goes on long enough, believe it or not, psychologically, going back to the traditional will seem different. Now, I hope that at least we would have both options on the table, and we can decide on the cases depending objectively on what is best suited for each case, and after carefully considering all parties' views. But to live with one option only, it is not the best available approach we have, of course. Now, going through the crystal ball predictions, interactive virtual platforms, I think that's the future, and I think arbitral institutions cannot anymore afford not having their own dedicated platforms, either their own or teaming up with a super high quality service provider. But you can't simply outsource this all the time, and many institutions are working on this. The ICSID have pioneered in having their own platform. The ICC have had for decades their net case, and working on a very promising project about this as well. Stockholm, they have their own platform. So again, I think this is one of the important projects that any institution now must have in place, their own online dedicated platform. Also to contain and maintain issues of confidentiality, cybersecurity, everything would be within your own reach rather than outsourcing this to others. Now, a standard feature in the new procedure order number 1 is reference to possibilities of virtual hearings and the use of technology or online hearings. That is new. Incorporating protocols on online hearings and the use of technology in parties' arbitration agreements, even, not just when the tribunal is constituted. Arbitration agreements themselves. And the Africa Arbitration Academy protocol includes template arbitration clauses integrating a virtual hearing option. Amendments to arbitration laws and rules, and I know there is a sweeping wave of amendments to put into effect the reality and put an end to the problems arising from the parties' disagreement about whether to proceed or not. So more guidance definitely would come in handy. New innovations about the procedural path, like, for example, possibly if we're going with virtual hearings, there could be possibilities for a virtual hearing after each round of submissions, so that parties have focused discussions. Tribunal would be well read and prepared for the case, and this could be more efficient and more cost effective. Another tool in the toolbox. I think hybrid hearings are the future, and I'm not the only one saying that. There are others saying this. I think having the virtual option on the table may mean that opening statements or oral pleadings could be done virtually. Cross-examination may proceed physically or virtually, depending on the case, but the hybrid option will present itself as the path forward. Issuing dedicated online rules. There are a number of institutions, as I mentioned, be it in Russia, China, or other jurisdictions, but I think now many institutions, including world-leading ones, are going to have their own set of online arbitration rules. Just like we've seen with emergency arbitration rules, expedited arbitration rules, we're going to have online arbitration rules for many of those institutions. Tech-savvy arbitrators. I think now more than ever, it is obvious that arbitrators need to be familiar with technology and able to use it well, because that is the future. I mean, 4 years ago, 5 years ago, I decided to go fully virtual with cases because going with suitcases with huge files and files that fill in a room would not work. So, and you're very comfortable with going fully electronic. It does take time to adapt, but once you do it, it becomes very easy and very useful. And I think that even resonates with Lucy's Greenswood approach about greener arbitration. So here you go. I think that's important. And then increasing recourse to purely online arbitration proceedings. And here you will see that I use the word purely online arbitration proceedings to distinguish it from using technology just as one component of the proceedings at large. And then, of course, artificial intelligence. And I don't want to dwell very much going to an end to my presentation on this, but I will end by saying that there are a lot in the pipeline, with this. Algorithms, predictive justice applications, which many have been talking about. I'll give you 3 without comments. and I assume now you're wondering. One is very clear, which is neurological chips. Instead of us saying artificial intelligence versus humans, I think the future is that you will have chip implants. You already have implants of people having steel structures or whatever. I'm not talking about supermen or superwoman type of thing, but to even correct certain deficiencies in DNAs or the faults in the brain, there are rectifying surgeries that include chips in the brain. So imagine if you want to digest more data or become a super efficient counsel or arbitrator, having a chip that digests this data and bring it to life. It is scary, but tests are being done. So here you go. Neurological sciences are coming into play and will soon find its way into the justice system. And you never know. And in the middle, we're not going to have handheld devices anymore. They're going to be something under the skin. And that's not a prediction. That's a reality. You see. So 3-5 component applications of something you don't need to hold anything. It's all built in under the skin. So that's, again, an interesting development. Whether we like it or not is a different question, but a reality. And the last one, I intentionally put it without making a reference. Now, to many of you, some people may think it's a calculator. It's a new type of mobile phone. It's a new type of electricity reader thing. But believe it or not, it's a portable lie detector. Portable lie detector. So the polygraphy of lie detecting and stuff is transformed. You have a portable lie detector with a sensor. Now imagine what this could do if it finds its way to international arbitration when cross-examining witnesses. Will it be admissible? Will tribunals rely on it? It's just portable. How is it going to transform the practices? Will it bring an end to witness testimony? Will it compel witnesses to say the truth? Will it be accurate? The witness may be saying the truth and may swear an oath on it, but the machine itself is not suggesting this. How are we going to deal with all that? And this is just the tip of the iceberg. I end with that note by saying that Tim Cook, Apple CEO, has said he does not fear artificial intelligence and computers thinking like humans. What he fears, and I think it's a very valid concern, is that humans becoming more like machines and thinking like computers. No compassion, no empathy, no value in terms of this intangible element of assessment that is yet to be measured. I'm not suggesting that science may not reach a stage where you can measure this, but at least in the point where we stand is that there is this intangible element that human brings into the process that is yet to be mimicked by artificial intelligence in a way. But again, we should not think of these as diametrically polarized options, because I said one of the way forward is you have hybrid type of things, chip implantations in humans. So you're still the human, but to what extent, which part will be taking over in a way? And it's not a science fiction movie. This is where we stand. And I end on this note by thanking you. And I hope I've not burdened you with speaking too much. And I hope, and I'm looking forward for any question and answer in this regard.
Thank you very much, Mohamed, Professor, for this very, very interesting presentation and comprehensive presentation. I hope that we have many years in front of us before your futuristic prediction happens. And we have some questions, and I will try to see which one you haven't answered. I think you answered to some of them in your concluding remark. Like one question was asked for the future of online arbitration, and it was phrased this way: how would we see online arbitration years to come, even after the pandemic is over, or how we are going to imagine conducting of arbitration proceeding in terms of online conducting of arbitration and vis-a-vis face-to-face arbitration. I think you answered this.
But I can add to it, yes. Nadia. But I'll tell you the following, and I think there is a very nice piece published by Elliot Geisinger some time ago on the future of traditional arbitration, not online arbitration, and how the new generations are handling things. For example, from the perspective of our children and the younger generation, emails are obsolete. Some of them even consider that other social media platforms are obsolete. They're using other, I don't want to give names, but they're using specific social media things. They're using shorthand writings, emotions, slang language. And the point is, when these generations take the helm and we become professionals, are we going to experience a situation where professional writing, presentation of evidence, will take a short shrift and will take a huge hit so that it mimics the lifestyle that they have been accustomed to throughout their lives? This may shed light on this. You may have emotions or emoticons and submissions. You may have submissions sent by WhatsApp, few pages, just bullet points, and that's it. They don't want to waste time because of the fast pace of life. I think everything is predictable. And I think there will be a complete overall transformation of these practices with the next generation. And I mean by that, after the next 10 years, all what we know about traditional arbitration practices will change. And online arbitration, at least for now, it does exist. I know to many it's presented as an option for small value, high volume cases, but nothing prevents parties from going fully online, paperless, no seat, no venue, using completely automated platform, elements of artificial intelligence into the process. And that could be what's happening. And as I mentioned, I may not be around when this happens. And for sure, I prefer not to be around when we lost control of our lives as humans and everything becomes fully automated, but it's a possibility.
Thank you. And there's another question about cross-examination of witnesses and how can we make sure that through virtual hearing on online dispute resolution that the witness is alone in the room where he's cross-examined. But I will give you the answer, the question. I think you can read it. In case I miss something, how can you guarantee that there's nobody else sitting with the witness? You have to cross-examine. And in an arbitration that I had the lawyer, she speaks about her experience that I had a lawyer who would cross-examine the witness, did not accept the virtual hearing, so we had the lawyer cross-examining the witness in person and the other lawyer participating online. I think that the witness has to be in front of the arbitrator no matter what.
That's true. Now, again, in traditional arbitration, we've all had cases where a witness could not make it to the hearing room for whatever reason, but they said we can connect virtually. And it happened, and that was well before COVID, years and years ago. And that was accommodated, and we set up a video conferencing, the witness is cross-examined, and that was, okay, grudgingly accepted, but because it was one-off or a minimal, or let's say, one instance. But what we're seeing now is that is the norm, and that everyone is doing that. Now, again, how can you guarantee? There are many ways. Now, again, in some of the late hearings I personally been engaged on, first of all, witnesses were not allowed to have a virtual background. The witness room was reviewed by a front and a rear camera. So you see a front and a back side camera so that you can see the whole room. Sometimes a 360 degrees room that is movable. So you can see what's happening. You check that they have nothing in front of them. Now, of course, to the maximum possible extent, and that is empty. There are ways to do that, but of course there will always be skepticism, and the skepticism and concern legitimately exists because you're not in the same place with them. You see what you can see, but you don't guarantee after what you see the situation will be as it has been seen.
I see.
I can't say it again this way, but I think it was correct. So it is, there are valid concerns. And of course, again, the witness is not under the same pressure when he is facing the cross-examiner face-to-face.
I see. Thank you. We have another question from Nicholas Stewart. And with a panel of arbitrators as opposed to a sole arbitrator, is the effectiveness of the panel during the actual hearing potentially significantly reduced if they're not physically together? And does that particular risk reducing the contribution of the non-presiding arbitrator, who, for example, cannot simply have a quick discrete word in the presiding arbitrator's ear, or find it harder to know when to raise a question?
That is an excellent question. Let me tell you, answer this practically, not in abstract. So, in the hearings I've had, it was a 3-member tribunal. And by the way, always including a female arbitrator. So what we have as arbitrators, now it takes 3 to tango. The 3 must be aligned on the ability to use technology. Now, if one is not able, then obviously the other 2 need to do an effort to bring him or her on par so that we can communicate. A number of things practically arise. Now, we have a breakout room virtually, so that room is ours. And let me tell you the following. And a breakout room on a virtual platform can have the following situation. Accidentally, the person who allocates the people to the breakout room may bring in counsel for one of the parties into your breakout room. And this has happened accidentally one time, by the way. Now, obviously, we are not saying something secretive or deliberating and stuff, and what was immediately rectified in 30 seconds, but a risk exists. Exactly like a risk when counsel opens the door and say, oh, I'm sorry, I'm in the wrong room. It does happen. Another thing, you're not physically, as Stuart has mentioned, giving an arbitrator a whisper in the ear. But what happens is that we have in the chat box option, private messaging. So we agree in advance that each one of us will be looking at the private messaging. Now, one of the serious issues, you have to make sure that you're addressing this to that person alone and not to everyone. Like sometimes when you click to all panelists and not privately. So you have to make sure that that is privately addressed. And we have in parallel the option of setting up another virtual room on a different platform throughout the day that we can exit this platform, go into it immediately to deliberate on a point. And also using WhatsApp or other applications that we can use as a chat function. We can mute, disable the video and have a discussion. And again, you have to be careful that you're not overheard. All these, again, come from the comfort of using technology. So everything is manageable. It's a question of how you have agreed to do it and whether the arbitrators have the minimum level of mastering the needed technology tools to make this efficient and proper deliberation and discussion as possible.
Thank you. I have a question of my own now. How do you deal with an arbitrator who's not tech savvy, one of the members of the panel?
Well, I'll tell you, I had in one case an arbitrator who's only used to papers. His use of emails is through his secretary. So, I mean, he does not use it himself. So you can imagine bringing him into a hearing on an application. It was not a merits hearing, but on an application live. It took several test runs. In fact, they had to bring in his IT person, his secretary, to set up everything for him and to make sure that you're only pressing these buttons, nothing else. And I had to be on phone with him. I mean, the president was in a different location and we agreed that I will have an open line with the phone to tell him what to do if need be. So not ideal situation. And that's why I'm saying arbitrators need to do the effort to do that. I, for one, do not understand why technology at that level is difficult, but I can appreciate that some may find it difficult. But if you do it and you get accustomed to doing it, that's fine. I mean, it works, but it is an issue for some.
It is, yes. The one other question is, what should the tribunal do in case of an oral arbitration hearing? When one party insists on recording all the proceedings, but the other side objects to it, except for witnesses examining.
So would we proceed in the, with a virtual hearing against an objection by one party?
I guess so. This is the way that the question is phrased.
But if that is the case, then we go to the 4th-tier test with the considerations on the 11 considerations under step 3, and we need to take that into consideration. The specificities of the case, the legal analysis, and the appropriateness of proceeding efficiently without breach of due process. Now, obviously, there are situations. I've had a case, for example, with involving an African party, where in the jurisdiction they are located, the internet connection is very bad. It is bad. What can you do? You can't force them to have a fully fledged merits hearing because it is not good. So the answer or the options were as follows: either a postponement, or that party with counsel would travel to a different jurisdiction, a close by jurisdiction, where internet connection is good. So there are options. There is another question, I think, about whether there is a case, Anna says a case under New York Convention where an award has not been recognized being totally online. We're still waiting for that first test case, but I can tell you my own thoughts on this. If one party was to object to recognition and enforcement exclusively, and please really mark my words, exclusively on the basis that the hearing was held virtually or remotely or online, and that party was represented, so there was no barriers to using technology, I don't see that objection flying. Why? Because courts themselves have seen and suffered from the inability to have a physical face-to-face hearing. So how can a judge who had to proceed online with hearings in a litigation would think that proceeding in an arbitration online exclusively because of that is problematic? But if there is an added element of a problem with due process, a party denied its right to reasonably or fully present its case, then the question becomes one of that issue, not of a virtual hearing per se.
I see. Thank you, Professor. There's Vladek, who's asking how can the original documents verified during online hearings?
That's another excellent question, but let me say the following. It is very rare that you see original documents anyway, be it in a physical hearing room, you always get copies. So if the question is about the authenticity of the documents, then online from offline, it doesn't make a difference, because the copy online is the copy that you hold it physically. But if it is about the authenticity of the document itself, then we go into the realm of verifying this through expert evidence, through checking signatures, date certification, stuff which relates to evidence rather than the mode of conducting the hearing. However, if we have, the issue is with how can we guarantee that a specific document appears online or that the full bundle is available online, I'm afraid counsel and parties and tribunals need to check that and ensure that there is enough protocols in place to have proper e-bundles and proper set bundles in a way that is appropriate to the tribunal.
Okay, thank you. And I think the last question, I hope I didn't miss any of them, has to do with the possibility to have a secretary on the virtual hearing, for virtual hearing. Is it possible to have secretary?
Of course.
The president.
Yes, yes, and that is interesting. Of course you have. And I think the reality of virtual hearings is that it's now easier more than ever for a number of things. You don't need to have your secretary in the same jurisdiction or the same office. You can have a tribunal secretary, which makes it easier for diversity and to bring in people from different jurisdictions as tribunal secretaries. Now, it is not an issue. You just need to make sure that the secretary is doing what, and agree with the parties the limits of what the secretary is doing, and to ensure that the secretary has proper, secure connection with the tribunal.
And how do you do that? How do you make sure that the technology standards are reached?
Of course. Well, a number of things. You can always, if the secretary is staying in his or her own home and their connection, or let me say the access is not proper enough, they can either go to a place where the connection is more secure, or have a login onto the intranet of the president's firm, if that is allowable, and access the bandwidth from there and then use it. So you can definitely have this as a possibility. It's just what is convenient and what works. But I can say one thing. Again, if someone wants to serve as a secretary to a tribunal, they need to have their technology sorted out, because the slightest issue with this will be a turnoff. Why would you go for X if Y is already capable and available and have the reliable technology?
I see. And there's one last question, has to do, it's Anna who's asking. She says, with regard to the fourth step, what if the lex arbitri is different to The seat requires a physical hearing. The lex arbitry expressly allows online.
Okay, so here again, it goes to the point more about the law and the rules. So we all know that the law of the seat of arbitration, or the applicable procedural law, their mandatory rules need to be preserved, because if you don't preserve them, you have a very high risk that an award could be vacated, set aside, or reversed in a way. But if the rules provide for virtual or ICT options, and the law says it must be physical, I'm yet to come across a law that says that expressly. If you have any idea, please let me know. But if that is expressly, and that is a mandatory requirement, then there is an issue, obviously, because it is a mandatory requirement, and you can't override that unless you're going to change the seat of arbitration by the parties' consent. But it's meant as part of the complete conceptual legal analysis that a tribunal needs to engage in, so that they can reason their order or decision to proceed or not to proceed virtually.
I see. Thank you very much. I think we are running out of time. I don't think, maybe, hold on, I just make sure that we have no other question. Yes, okay. It's the people who ask questions and the attendee are thanking you for your answers.
I'm very grateful to all our colleagues who said questions, and I see some friends among the questions, and I wish them all the best. I think some of them asked the questions and left, but again, it has been an immense pleasure being part of this. If there is another question, I'm happy to answer. I'm perfectly fine with that.
I think we've covered them all.
For it. And again, I'm very grateful for you and Nikos for arranging that, and I hope it was not boring.
No, it was a pleasure, as usual, to listen to the depth of knowledge that you have in every topic that you discuss. You decide to tackle international arbitration. It was a real pleasure to have you, Professor. I thank everybody for attending. Nikos, do you have something to say?
Well, I have. I also thank Professor Mohamed, for the excellent presentation and practical issues that were touched. And I would like to finish with a comment from my friend Minaska Chadurian in the chat, where he said success stories of online arbitration hearings and statistics published regularly by the arbitration institutions shall forge trust in a fully fledged virtual arbitration, whether for large or small arbitrations. The only thing I would add to that is, besides the success stories and statistics, maybe some training for arbitrators as well.
Absolutely.
In tech issues.
Absolutely. And I'm very grateful for our dear friend Minas. So I'm delighted to see that he joined us. And an excellent point. Of course, forging trust is part of testing, using, and having some useful statistics. And if institutions who are now publishing statistics about diversity, caseload, and stuff begin to publish, whether we go wholly and virtually online, it would definitely be useful. Now, the caseload is building up. And we will definitely, as I mentioned, I foresee that many institutions, as part of either marketing efforts or catering for the rising demand in this, will have dedicated online arbitration rules, something that I've been advocating for years. So I think that's going to happen. We see that already taking place. With this, I think you will be able to forge more trust and more training on these matters. But I think trainings on this with arbitrators, you don't need to have arbitrators who are IT engineers. That's not the idea. But you need to have arbitrators who are familiar with technology, comfortable with using it, able to handle the normal pitfalls and issues that may arise in the context of the hearings. Now, of course, if you've done technology trainings and stuff, it's an added plus. But now we live in a world where data protection, data availability, cybersecurity is an issue, and you need to familiarize yourself with all this. We're now being educated on a daily basis with phishing scams, botnet issues, spyware. We're facing that. So if you take this level up into how remote or online hearings or online arbitrations are being conducted, you're doing yourself and the global arbitration community a service, because otherwise you're not going to survive. It's part of the Darwinian adaptation thing.
Right. Thank you very much. I thank Professor again, and I would like to thank all the participants for being here today. And if you have any questions after we finish the webinar, you can actually send them to us, and we'll try and answer them. Thank you very much all, and have a good evening.
Thank you very much.
Bye.
Have a good evening. Bye.